This meeting is being recorded.
So can everybody see my screen at this point? And here's the thing is that by putting up the PowerPoint, I've lost all visual and I've lost the chat. So I'm just going to rely on Pamela if there's a chat question to let me know what that is.
I'll monitor the chat if I can. Yep, I can see the chat now, I think. Yes.
Okay. So just let me know that because all I can see is my PowerPoint.
Okay, sounds good.
So, well, it is true that what I'm going to talk to you today about is mandatory reporting. I am setting it within a larger context because I think that to be able to really understand mandatory reporting, you first have to understand the confidentiality framework that we work within. And it's great to see some folks or see your names. It hasn't been that long since I was over at Violence Free Minnesota, so it's great to be able to come back and be able to do this. But I would say this, that while my background includes both being an attorney, I'm not an attorney who specializes in this area of the law, but I've done a lot of work around it in my various roles. And that where I've come at this is really from how do we do advocacy work within the framework of confidentiality and mandatory reporting that is required of us. So that's just kind of my framework on this. And where I like to start is talking about confidentiality. You know, confidentiality is really the cornerstone of advocacy work that for the folks that we work with to trust us, right? They have to make sure that they can, that they know what they, that what they tell us will remain confidential, and that we will tell them where are the areas that these are things that if you tell me that I will have to share with other folks, or I'll have to share under these contexts. So being really like sort of clear and transparent, but really having confidentiality around a lot of what we do is really essential to be able to do the work we do with victims and survivors. And there are also some real safety considerations, right, about what information gets out about people, and that information can be used in ways to really compromise people's safety. So confidentiality is really the cornerstone of the work that we all do. And I think it's important to understand and to remember that as sort of the foundation. So I always start with, what is it that you cannot share? What information are you prohibited from sharing? And we are prohibited from sharing personally identifying information about a victim, survivor, or people that you serve within your program. Okay, so that's what you cannot share, is personally identifying information. And so who says you can't share it? There's two primary sources. One is funders, and it'll be language that's built into your contracts, and there are statutes that say you can't share it. So in terms of funders, it used to be that we used to always talk about if you received VAWA funding or federal funding from the Department of Justice, from the Violence Against Women Act office, right? That they had the most strict rules around what you cannot share. But over the years, every other major funding source for work with domestic and sexual violence and sex trafficked folks have taken up the same standards. So if you receive money from the federal government, even if it flows through the state, so if you get Violence Against Women Act money, if you get the Family Violence Prevention Services Act money from DHS, if you get Victims of Crime Act money, VOCA money, a big source of funding right now in the state, right? All those federal sources, and then also the Office of Justice Programming, Minnesota's primary funder of this work. They all require you to not share personally identifying information of the people that you work with. Okay, so if you look at your contracts, those obligations are built right in there. So that's the first place in which you cannot share information from your funders. So even to your funders, you can't share it. So if OJP comes out and does an audit of your books, you have to redact or black out the personally identifying information. That's why you always, information gets reported back to them in aggregates, right? So I can tell you we've served X number of people. or, in this age category, or, right, this number of people who have this disability, right? But you can't talk in the individual identifying ways. The other place which says you cannot share information is under the Minnesota statutes. So both sexual assault advocates and domestic violence advocates have specific places it's in the same statute, different subdivisions, that say that the information that we have and that we gather on persons that we work with is confidential, right? And so those are the places that say you can't share this information. So it leads you to the question, what is personally identifying information? Okay, so some of this, okay, somebody's name, their social security number, their date of birth, right? Those are pretty obvious, right? Their home address. So sharing, even if you say, you don't say that the children's name, but you say this is who their parents are, you've identified them, right? So these are, all those ways that you can very clearly tell what is personally identifying information. But personally identifying information is even broader than this sort of list of name, social security number, that kind of thing. So what do I mean? So let me give you an example, okay? I could say, I am working with a young woman. She's 19 years old and she has a 2-year-old child, okay? Would you know who I'm talking about? Probably not, right? Okay, because, that's a pretty broad description, right? Now you compare that to, I'm working with a young woman. She's 19 years old, has a 2-year-old child with severe disabilities due to being shaken as a baby. She dropped out of school and has just returned to Mr. X's class at Y school. Okay, I have not said her name. I've not given you her social security number. I haven't told you where she lived, right? But I have given you enough information that more than likely you know exactly who I'm talking about, right? This is personally identifying information and it's prohibited, right? You can't share that level of information. The first statement, I'm working with a young woman, she's 19, she has a 2-year-old child, right? That's not personally identifying. The second statement most likely is. And I always say it, and I can't tell you specifically what's personally identifying information across the boards, because I could say I'm working, if I'm working in St. Paul with a Hmong woman with 5 children. Have I personally identified somebody? Probably not. But I can tell you that if I was in Baudette, Minnesota, which is up on the Canadian border, and I said I'm working with a Hmong woman with 5 children, odds are there are not too many Hmong women with 5 children living in Baudette, a tiny rural community on the Canadian border, right? So it's contextual, what is personally identifying information. If the information I shared with you in the context in which we're functioning identifies somebody, that's what's prohibited. So like you may be working within a school system, right? Or you're working in like a sexual assault response team, right? And you have, right, a small group of folks that you're working with. You have to be even more careful about who you're identifying, right? Because a lot of times we talk in terms of hypotheticals, right? But does your hypothetical actually identify the person? And it can't be one of these things where it's like, like wink, wink, nod, nod. We all know who we're talking about, but I'm not saying their name. You can't do that, right? You cannot give out personally identifying information. So that's kind of the bottom line, okay? Now you're probably all thinking, but wait, we do share personally identifying information. So you can't share personally identifying information unless one of 3 things exists. The one would be you have a signed release of information from the person, okay? Then you can share that information. The second would be you actually have a court order that tells you can release the information. Or the third is that there's some law or statute that requires you to share the information. So I'm going to break these down a little bit. No personally identifying information shared unless there's a signed release of information. Now, there are various requirements about the release of information. It has to be voluntary, right? So it can't be, in order to get services from our program, you have to sign this release of information. That is not voluntary, right? So one of the places this will pop up is Child Protective Services. They may show up with a signed release of information, right? Is it really voluntary? Or did somebody feel like in order to see my kids, I had to sign this release of information, right? You have an obligation to make sure that the signed release of information was done voluntarily. It also has to be in writing. It has to be what's called informed, which means the person has to understand what information they're giving, who's going to have access to it, what's the impact of sharing that information. The other thing is it's supposed to be time limited. So if you have a release of information form that has no end date to it, that doesn't comply with what you need. And it's going to be based on the situation. So if this is information that's just going to be needed in the next couple of weeks, then having a release of information that's good for 1 month is probably appropriate. If you're going to be working with, say, with a classroom teacher jointly over the next semester, then maybe you want a 6-month, and it's appropriate to have a 6-month release of information, right? So these are sort of the requirements that for release of personally identifying information, you have to have a release of information that complies with these standards. So that's release of information. And we work with that all the time. Programs have, you should have a release of information form you use. If you have any questions about whether your release of information form complies with the requirements of the funding sources standpoint, and I'm going to give you their information at the end of this presentation, are a really good resource. They will give you sample releases of information, or they'll look at yours and give you suggestions about whether it fully complies the way it should. So, release of information. So if you don't have a release of information, you can share personally identifying information if there's a court order. And here, I just want to be clear, what are not court orders? A subpoena is not a court order. One of the things is, I'm an attorney. I practiced, had a private practice for a while. Like I could, at my own computer, type up a subpoena and issue it. No judge ever had to see that subpoena. As an attorney licensed in the state, I can issue my own subpoenas, right? Subpoenas are not court orders. So if somebody shows up with a subpoena and says, you have to give us personally identifying information, you can't do it if that's all you've got, okay? One of the other places where court orders come is the court often, if a guardian ad litem is appointed to a case, they oftentimes will do an appointing order for the guardian ad litem. And that order will oftentimes say something like, anybody you talk to has to give you information, right? Or some language like that, right? That doesn't count, even though it's issued after a court hearing and the court signed off. The law is clear that a court order has to have happened after you, as the person who holds the information, have a right to participate in that hearing and to make your arguments. And the statutes are, the state statute sets out some really clear parameters around that. So a court order, just the biggest things that come up are usually subpoenas, where people say, I got a subpoena, don't I have to? No, you can't, if all you have is a subpoena. So release of information, court order. The third way you can release information is by law or statute. And the most common one is the mandatory reporting statute. So see how we got to mandatory reporting? So that's the backdrop of understanding confidentiality, and where does mandatory reporting come in? So, and if you must share under any of these things, release of information, court order, or mandatory reporting, 2 other requirements. You must let the victim survivor, the person whose information you're releasing, you must let them know you're releasing the personally identifying information. That's an absolute. And you can only share what is required. So if the release of information says you can share this information, you can share the release information says you can say that I participated in this group, right? Then you can share information about participating in a group. You can't then go on and talk about other information that you have, right? The release was only for this information. That's all you can release. The court order, after hearing, it'll say what you can release. If it's not in that little like descriptor, can't release it. And that's also going to be true, and we'll talk about that with mandatory reporting. Okay? So I'm just this is really about understanding the basis before we move into mandatory reporting. So if you have a survivor who signed a release of information, says, you can share my information with the school counselor about issues she's having with her mother, okay? The student's teacher, who's been very, very supportive, asked to talk with you about problematic behavior by the student's mother. Can you talk with the teacher? Well, the answer is yes, you can talk, but you can't share information. You can't share personally identifying information because your release is only to the school counselor. It is not to the teacher. So you can have a conversation, but you can't release personal information, no matter how connected they may look, no matter how supportive they are, right? Your release of information says you can only give it to the school counselor, right? You'd have to go back and get a signed release of information that also includes the teacher. Okay. Now, what the school counselor does with the information is under the school counselor's guidance, but you can't do it. Okay, second scenario. The school counselor has a signed release of information from student X, saying that you can share information about your work with student X. Can you share information? The answer is no. Because you don't know that that was a voluntary release of information. You don't know that student X has been fully informed, right? So you would first have to have a conversation with student X to determine, is this a valid release of information? And actually the best practice would be to have a release of information that you have them sign, right? So you might be able to release it, but you've got to take a few steps to confirm that the student understood who was going to see the information, the impact of that information, that it was truly voluntary before you can go forward and share information. Last one here. Student signed a release of information, said you can share information with the school therapist that the student is participating in your program. Student calls you up and says she doesn't want you to share any more information. The therapist calls you and asks you some questions on notes that you sent a couple weeks ago. Can you talk to the therapist? And the answer is no, because the student is in control. The person who the information is about is in control. So even though you correctly sent over your notes under a release of information, if the student then resends that release of information, it then stops your ability to share personally identifying information, right? So that's just how, just wanted to cover some of that stuff before we go on to mandatory reporting. So can't share personally identifying information unless, and the third category was the law requires it. So mandatory reporting of child maltreatment. That's how it's talked about in statute, is child maltreatment. And it's under Minnesota Statute 260E, if you ever want to look it up specifically. So the three things I'm going to talk about is who is a mandatory reporter, what is child maltreatment, and how do you report, okay? So who is a mandatory reporter? So the statute lists out a list of people, and this is most of the people. I've abbreviated some of this stuff, right? So, so part of this is, what does your program do, right? Some programs actually have mental health workers or healthcare workers as part of your organization, right? So they're very specifically called out as mandatory reporters. Some of your programs offer childcare as part of your programming. Those who provide childcare are mandatory reporters. There's some very specific things around education, right? Guardian ad litems, folks in the corrections field, law enforcement, social services, and social workers, right? And then clergy, and they're an odd category, and I'm not going to go into it. They have kind of a hybrid kind of mandatory report. under certain circumstances. So you think, it doesn't say advocates on this list, does it? So how do advocates become mandatory reporters? So, and it's a little bit complicated. So anybody who's hired as an advocate is typically, it's under this catch-all social services. That oftentimes is how folks get identified as mandatory reporters, right? Now, some folks who, and I think it's important to understand what is your job. So if I am hired by, I know I don't believe WISE has this, but WISE has hired me. I have my social work license, and you hire me as a social worker to provide mental health services. I'm a mandatory reporter primarily as a mental health worker, okay? I could be, have my social work license, and I got hired as an advocate by WISE. I'm not doing mental health work per se, right? Then I'm primarily a mandatory reporter as an advocate. And there's a few other things that follow with that. But that's kind of how to think about it, right? So what is the job you are hired into? That's what makes you potentially a mandatory reporter. And what I would say is that I believe that all of the programs, all the domestic and sexual violence and sex trafficking programs in the state, I believe, do consider their staff mandatory reporters of child maltreatment. Okay, so the first question. So yes, it is the general practice and the general sort of wisdom that all advocates are mandatory reporters. And sometimes this is built right into your contracts, depending on who you're contracting with. So as another reinforcement. So then there's this question of like, if you're a licensed social worker, but working as an advocate, right? What does that mean for you? And one of the primary differences is if you're considered a mandatory reporter because you're a licensed social worker, you have your MSW, say. The way that licensing works, it's considered that you're a mandatory reporter 24 hours a day, 7 days a week, okay? If I am hired as an advocate, right, I am a mandatory reporter when I am working as an advocate, okay? So let me give you an example. So say I'm at home at night and I see that my next door neighbor is physically assaulting their child, okay? If, as an advocate, if I was doing a home visit as part of my job and I saw that, that would be mandatory reporting. I'm off of work. I'm sitting in my backyard, right? Just chatting with a friend, right? I see this child maltreatment occur. I am not mandated to report that because I'm not working. The difference is that if you're a licensed social worker, it's considered that you're a mandatory reporter whether you observe something at work or not. So that's a difference in those two scenarios. And it doesn't matter if you're what you're hired at or if you're even working any place. As a licensed social worker, you're considered a mandatory reporter. So say I'm working within the program. So I'm at Transforming Generations. I do administrative work for the organization, but I don't do any advocacy. But I've come across information about child abuse. Do I have to report it? Am I considered a mandatory reporter? So there's a couple of questions I would have. If you gain the information from the workplace, so it's the same scenario, like am I off work or am I on work? So if you gained the information while you were working, right? And then how did you gain the information? The reason I have the information is because we're a small organization and when we're short-staffed, people who do primarily administrative work sometimes fill in, right? So even though you don't typically do advocacy, right, you were doing some fill-in work, or right, you're going to be considered a mandatory reporter. If the information came to you through the workplace, even if your job is not that of an advocate, you're still going to be considered, your organization is a mandatory report organization. So really thinking about it in that way. So a couple other things I would say this is that anybody can voluntarily make a child maltreatment report. So if I'm sitting in my backyard and my neighbor is assaulting the child next door, I'm not mandated to report that, but I certainly can. I can make a voluntary report. Anybody can. But mandatory reporters must make child maltreatment reports. So, and the consequences are, the statute says if you are a mandatory reporter and you fail to make a report, criminal charges could be brought against you. Now, I have known of a couple of cases across, I've been doing this work 36 years, something like that. I know of, I can think of 2 times where I know that somebody came up as a mandatory reporter. And these were not unlike some of these cases like, is this a report or isn't this? These were very clear cases where somebody should have taken action and did not, and pretty clear-cut cases. But right, so mandatory reports, you must make a report. If you're not a mandatory reporter, anyone can voluntarily report in. Okay? So that just tells you who is a mandatory reporter. And I'm assuming if there are any questions, they're coming through the chat, and Pamela's going to let me know. So then the question is, what do you have to report? And what you have to report is if you know or have reason to believe a child is being maltreated or has been maltreated within the preceding 3 years. That's what you have to report. You get that? Know or have reason to believe a child is being maltreated now or in the past 3 years. So a child, by statutory definition, under the age of 18, right? The law does not make a distinction between an infant, a 5-year-old, or a 17-year-old in terms of this reporting, right? A child, okay? So, and it's being maltreated. Now, here is where the statute does go into a lot of detail about what do we mean by maltreated, okay? So this isn't all of the categories, but this is under, Minnesota Statute 260E. Under the definitions part, at the top of the statute, it lays out and defines various terms, okay? Now, some of these, physical abuse. What do we mean by physical abuse, right? The statute says anything, it means physical injury. Where is it? Let me get to the right section. Look at 18. Oh, and they actually list out things like, it's injury caused, physical injury caused that from actions that are not reasonable or moderate, right? So a lot of mushiness here, right? Things like throwing, kicking, burning, biting, striking a child with a closed fist, right, versus an open hand, shaking a child under the age of 3, right? Unreasonable interference with a child's breathing, so smothering a child, right? Threatening a child with a weapon, right? Striking a child under the age of 1 on the face or head, right? So there's some really clear, right? It's not just limited to these, but they define out what they consider physical abuse. So one of the things that's important to do is to look at that and to say, if these things are happening, so if you have information that there was a child who was physically assaulted and injured, which typically means there's evidence of a physical, right? Like there's a bruise, like, right? And it's a child under the age of 1 and you see a handprint across their face. That's clearly talked about in statute, and people are going to see that as maltreatment, okay? So you've got, compare that with a 16-year-old and you have a parent who slapped them across the face, no mark was left, okay? That's not quite clear whether that's maltreatment under the definition or not, okay? So that's why I'm going to say that while it seems like there's really clear definitions, in some ways they're clear, in some places they're not, right? And that becomes more difficult to determine. The other thing to realize is about the various kinds of maltreatment, like physical abuse, threatened injury, substantial child endangerment, everything other than the sexual abuse category, that it's also important who did the action. And for most things, it's considered maltreatment if the action, the person who did the abuse was a parent or guardian, somebody responsible for the child's care. And this is where you also get into things like facilities. So if you have like a juvenile who's in a correctional facility, I'm not going to get into those in treatment programs. I'm really talking about like within our programs. So with sex abuse, it doesn't matter the relationship, right? Anyone who does sexual abuse, as it's defined by statute, it's considered a mandatory report. So, and sex abuse, it's like all the criminal sexual conducts statutes, right? As well as sex trafficking are all combined under sexual abuse. And so that's the one that it doesn't matter what the relationship is between the person who committed the abuse and the child. The other one's somebody who's responsible for their care. Now, the other thing is as you see even here, the other categories, substantial child endangerment, threatened injury, mental injury, these are a whole lot less well defined, right? But the statutes do make it pretty clear that they're looking at something fairly substantial. So like mental injury, the definition actually says an injury to the psychological capacity or emotional stability of a child as evidenced by an observable or substantial impairment in the child's ability to function within a normal range of performance and behavior with due regard to the child's culture. Okay, pretty convoluted, right? But basically, it's sort of, they're really looking like there's something that was a mental injury, and you're seeing this very definitely impacting the child's real ability to be able to function. Okay, so the same sort of thing with like neglect. I don't know why I didn't put neglect up there. It's a huge category, right? Neglect is another category. So what is neglect, right? That's a pretty broad term, but it means under the law, things like failing to provide a child with their basic needs, like food, clothing, shelter, right? So if you have a child who is not, right, who, you know, you have a 5-year-old and they're withholding food in a substantial manner, right, such that there's a growth delay or failure to thrive, right? So it's not just like, you know, right, so you have to not only show this behavior, but you have to show its impact on the child, okay? There's also, so like chronic and severe use of alcohol by the parent, guardian, personal responsible may be child maltreatment if it adversely affects the child's basic needs and safety, right? So if you have a parent who is chronically and severely using alcohol, but they make sure that the child is cared for, that's not maltreatment, right? It's the severe and chronic use of alcohol that adversely impacts the child's needs and safety. So that's sort of how maltreatment is defined. I'm going to go on. We'll kind of keep circling back to this a little bit about how do you actually work with this, because it's not like here are the 5 things. If you see one of these 5 things, you have to report, right? And what I would also say is, I think where people find it easier is if you have information about physical or sexual abuse is much easier than things like neglect, mental injury, right? Those are much harder areas to decide, is this a maltreatment that rises to the level to report, okay? So the other thing that goes here is the definition was you know or have reason to know a child, a minor, has been maltreated within the past 3 years, right? So is there child maltreatment? Has it happened within the past 3 years? Do you know or have reason to know? And I'm going to come back to this. And do you have that information because you're a mandatory reporter? Okay. So a couple things to think about here. Like, you may have information about a child being maltreated because it's information that you've heard in the community. That doesn't make you a mandatory reporter if you're coming into this as an advocate, right? Do you have the information because you're a mandatory reporter? Does the information come to you under your job, right? It's not just because I heard it in the community. I observed it when I was off of work, okay? So so some of the questions that I oftentimes look at is, how do you have this information, right? If you believe a child is being maltreated, and if you came to me to talk to me about, is this a mandatory report? One of the first questions I'm going to ask you is, how do you have this information? Do you have this information because the child or the youth told you directly, right? That's a pretty clear-cut case, right? Do you have this information because you observed or saw something directly? Pretty clear-cut, right? Did you get this report from somebody else, right? And then it really depends who reported it to you. I was talking with a parent who was really upset and was feeling like they were being attacked for their parenting, and they made an accusation about the other parent. Do you believe it? Do you not? And that's where you need to take the context of what you're dealing with, right? Because the standard is, or you have a reason to know child maltreatment has happened, right? So how do you have the information? Next question is, why do you believe it, right? It may well be I've worked with a lot of victims of domestic and sexual violence, and what I'm hearing reported is absolutely in line with that, right? I mean, that may be your basis, and that would be a reasonable thing to believe, right? So how do you know it? Why do you believe it? Then is it child maltreatment, right? It may be bad parenting. It may be inappropriate. Is it child maltreatment? And that's where really going back and looking at the definitions under the statute, right? Somebody was sexually assaulted, right? You have an adult who has sexually assaulted a minor. That's pretty clear cut. But the other thing is that physical discipline is not child maltreatment, right? So what's the difference? One of the standards under what's considered permissible physical discipline is you can use physical discipline, but you cannot leave an injury. You can't leave a mark, okay? Now, you may personally disagree with that standard. You may think that's bad parenting, but is it child maltreatment, right? So that's the other part of the question here. And then the last question is, did it happen in the past 3 years? That's the window, right? It's a 3-year look back. So we're going to circle back to this again, a little bit of repetition. But if you have reason, or have reason to believe a child has been maltreated, you must report. So where do you make the report? If it's an emergency situation, you're to make the report directly to law enforcement. The reason being, if it's an emergency, you need intervention right now, right? If it's non-emergency, then you can either report to law enforcement or to child welfare, child protection. If you don't know where you're supposed to report, you should call the child welfare office and say, I need to make a report. They may ask you a few questions. They might direct you to local law enforcement, or they may just take the report. Okay? So that's where you report. And then you're required to verbally report within 24 hours of learning of the child maltreatment, and to follow that up with a written report within 72 hours. Okay? And you may well call into Child Protective Services and they ask you just to do a written report right off. If they ask you to do it that way, then you've met both requirements. But if you call up and you report something verbally, you are still required to follow it up with a written report within 72 hours. Okay? So this is kind of like laying out the steps from And so the first thing I say before you even get into this, you should have a standard practice going on that you let the people you serve know that you're a mandatory reporter of child maltreatment. It goes way back to talking about confidentiality and trust building, that you have an obligation to let people know that you're a mandatory reporter, that if you get information about child maltreatment, that you are required to do something with that. So you should be letting people, and you should have a standard practice about how you do that. And just saying I'm a mandatory reporter of child maltreatment is not good practice. What does that mean, right? We're having a training here to figure out what it means, right? So letting people know what that means. So the first step is that if you know or have reason to know that a child was maltreated in the past 3 years, boom, that's the first step. Now, I've put in bold the 3 things that are required by law. The other things in here are what I call are fairly standard best practices, okay? So most programs I know of have a process by which if you're non-supervisor, if you have reason to know, most programs have a practice that say that you will talk with your supervisor. You will let your supervisor know that you think you need to make a child maltreatment report, okay? And that there's a process. It's like talking it through. And so typically that's like, let's go through this. How do you get the information? Why do you believe it? What do you know? What's the plan of action, right? Right, so that's a fairly standard. And if you don't have that in play, I would encourage you to look at building that into your process. The next thing is you have to let the victim survivor know you're making the report, right? You don't get to do this and not tell them. Your funding sources require you to let the victim survivor know you're making the report, okay? The other thing as best practice is that you should be offering advocacy to the victim survivor, right? You don't just say, I'm making this report, figure it out from here, right? You have relationships with folks, you're going to work with them, right? And let them know. So then what are you required to do? You have to contact either law enforcement or child welfare. You make the verbal report within 24 hours, followed up with a written report within 72. So if you know something, talk to your supervisor, let the victim survivor know you're making the report, figure out an advocacy plan, do a verbal report, a written report, okay? And the other thing I've just put out there, it's obvious, but I like to say it, is that advocacy continues even after your report, right? That we continue to do our work even though you've done a report, okay? So, some common questions. Law enforcement already knows about the child maltreatment. They responded to the call about child sex abuse, right? They're the ones that called you. Do you still need to make a report? Yes, you do. Just because another mandatory reporter has reported does not release you from your obligation, okay? They may not do much with it because law enforcement's already reported it, but you still have to make the report. I spoke with my supervisor and she's going to call Child Protective Services. Do I still need to report? Yes, you do, right? It could be you can do it on the same call with your supervisor, but if you as the mandatory reporter are the one that got the information, you have an obligation to report, even if somebody else within your program makes the report. And you can do it jointly, right? Which is probably what I would recommend. Okay, I've been working with this person for the last 6 months. They just told me that they were being sexually assaulted by their stepfather about a year ago. Do I have to report? Well, and here are the steps. Yes, you probably do, right? Assuming that the person you're working with is under the age of 18, right? Are they a child? Sexually assaulted by their stepfather would be child maltreatment. They told you directly, right? So you probably believe them, right? You have reason to know. And it happened in the last 3 years. So you have to report, okay? If the sexual abuse was from 4 years ago, no. If the sexual abuse ended, right? If it started 4 years ago and was ongoing, then you would have to. But if it was 4 years ago and in the last 3 years there hasn't been any, then you don't have a mandatory report situation. Okay. Now, what I would remind you is that there may be reasons you want to take action, but you're going to be taking action not under the mandatory reporting statute. And then, right, you can't release personally identifying information unless, right, you have a signed release, a court order. You can't release that information under your mandatory report obligations because this is not a mandatory report if it hasn't happened in the last 3 years. So that's why it's helpful to understand. You may have a student who really wants you to share this information and to help report it. Then you're going to need a release of information, right? You're working with a young person, was beaten up by their boyfriend. Do I need to report under child maltreatment? So the first question I'd ask you is the young person you're working with, are they under the age of 18? Okay, are they a child? If they're under the age of 18, so they were beaten up by their boyfriend. If it was a physical assault, it is not maltreatment because physical assault is by a guardian or a person responsible for their care. And that's not the definition of a boyfriend, right? Now, if, say you had a 17-year-old who was raped by her boyfriend, now you have sexual abuse of a minor, and that is a report because under sexual abuse, it's anybody. Under physical abuse and the other categories, it's a person responsible, so parent guardian type person. So does it matter?
I have a question on that.
Yep.
Oh, you're doing, okay, never mind. Keep going.
So does it matter if the boyfriend is under 18 years old? Okay. Now, and this is where, right? So if it's sexual abuse, right? That's the only place where you're mandated to report when it's a boyfriend, right? A dating relationship kind of thing, right? So in the sexual abuse portions of the mandatory report statute were changed. There was a lot of fighting and legal wrangling around this over a number of years. So the current language is very broad, okay? And I believe, and this is where, because it says that a person who has a significant relationship with the child, if that's the person and it's sexual abuse, then it is a mandatory report. What people were trying to capture was sex trafficking type things, but the way they wrote the language, I believe it would include a dating relationship. That's my read of it. Does that answer your question, Pamela?
No. So
give me a question.
So when I was the executive director at Sexual Violence Center, we would not have made a report if we were working with a victim survivor who it was the boyfriend who sexually assaulted her, and let's say they're both 16 or 17, right?
Right.
If she didn't want it reported, we wouldn't have made a report. Now, if he was, if she was 16 and he was 30, that we could consider it differently. But since, the age of consent is 16, and yes, of course, this isn't consent, but because we wanted to make sure that they still felt they could trust us and they could continue to come to us, because our fear was that we start reporting all of this and we did not see it as a mandated report, depending on the age of the student, the relationship, the age of the boyfriend, et cetera. So
so no, I absolutely get you. And this has been what the wrangling was out for many years about this definition, right? And so one, I would say when you were executive director at Sexual Violence Center, the law was different. That's the first thing I would note, right? It still had the person responsible, right? So a boyfriend, a dating relationship would never fall in this category, right? Same as with physical abuse. So that's one thing, the law has changed. The second thing is this, I think there is an argument because sexual abuse, they tie it to the criminal sexual conduct statutes. So, and anybody who's worked with the criminal sexual statutes, right, it depends, was there penetration, was there force, was there a weapon, was there, right? So what's the level of what happened? there's also some of the consent stuff you're talking about, the age differentials built into those criminal stat, right? So part of it depends what happened, what was, right? So if it's, so that's when I said it, so if there was a sexual relationship, doesn't necessarily equate to sexual abuse under the statute. And that's where it gets very complicated, right? So that would be the way in which I would work through it. It's like, so what's the information you have about potential maltreatment? And if it's like boyfriend and there was sexual abuse, then it's like, how are you defining sexual abuse? What actually happened? And how does that fit? Yeah, and does it create some situations where it's going to be not, it'll be detrimental to make a report? I think probably. And that's why there was quite a fight around the change of the statute. But ultimately, the statute was changed.
And then Yvette, you had a question?
Yeah, I have a question, Liz. It's good to see
Yeah.
you, by the way.
Yeah.
So let's, for a minute, let's think. We know, according to the statute, there is a situation of sexual abuse. And these are both teens, both are 16. But we know there was sexual relationship, and according to the statute, there was sexual abuse. Would we report then or no?
Yeah, just because they're a minor, the law does not make a distinction.
Okay.
Yep. And actually, I'm going to go to the next. I know we're getting here, but I just have one other slide, which I'm going to show you the questions. So, but here is, I want to give people standpoints information. You can just look at Minnesota Standpoint, get all this information there. They really are an organization in the state which, you know, mandatory reporting, confidentiality, release of information, that's one of their areas of expertise. And so I would really, when you have questions, I would use them. And I'm going to stop sharing my screen so we can actually answer questions and I can see you.
And Liz, I would say too, I would encourage people to talk to Standpoint too, because I have done, you know, hypotheticals to, at least in Ramsey County, and where I had no idea what the time frame was. And because it was sexual abuse, they wanted a report. So they knew that there wasn't a, you know, I didn't have the perpetrator and I didn't have the time frame. But because it was sexual and it was a minor, they wanted me to do the report. So I would say run it by Standpoint, because the county might err on the side of, yes, everybody should just report because it's sexual abuse. So.
Right, and that's where I would say, yeah, so I know that some people have a practice of calling up child protection with hypotheticals. Now that's fine, you can use hypotheticals, it's not releasing information. I don't think that's best practice. I do think, you know, depending on your child protection, yeah, there are some where it's just like, no, report in everything, right? They're always going to tell you to report in, right? And I think it's important for programs to be really clear about when you're sharing information and when you're not, and why you are and why you're not. The other thing I would say is this, is that even if you believe, so say that you're working with somebody and you believe it's a mandatory report, remember, you're only allowed to share the information that is around maltreatment, right? That's what you're mandatorily reported to, right? So you may then get in this conversation where they're like, well, can you tell me about X, Y, and Z? You start getting these calls back, right? And it's like, no, that's outside of the discussion of the maltreatment, right? So that's why, you know, being really clear about what is it I'm required to report, right? This is what I can report. Now, oftentimes, like, so, right, so it's things like, so you're reported in, you're working with the young person, and then they want to know, is this person involved in your other program? You know, they're coming regularly to groups. You can't release that information. That is not part of the mandatory report, right? It might be helpful to them in child protection, but to release that, you're going to need a release of information, right? So that's why understanding personally identifying information, under what theory are you releasing it, and how do you go about doing that? And so, yep, just because you're now required to report something doesn't mean like the floodgates are open, right? It means this is the information, maltreatment information can get released.
There's
And it may be
another situation we've had is, let's say somebody makes a report, and of course they always go to the school, right? Because the kid's
Right.
not at home and and the school had wanted that if we were doing any reports, they wanted us to tell them. And my thing is, yeah, under confidentiality and everything else, we can't do that, right?
No, because right, the mandatory, right, they're not a reporter. It doesn't say report to law enforcement or the school, right? Right. So that's where your report goes. Now, if child protection wants to share the information back with the school, that's on child protection, right? Your obligation, you can only share that back with the school if you have a release of information, you have a court order, right? That's how you release it back to the school. And so, yeah, and it's not like, and that's where going back to why can't you release? We're required by law and by our funders to not release this information. It's not that you're not wanting to be a good partner, right? This is your obligation. And these were set up because confidentiality is important. And it's a safety concern, it's a trust building thing, right? That's why these rules exist. So that's why I think it's helpful to know the whole parameters of how information gets shared. So you know where you're functioning, which is also why it's best practice to have a supervisor help you sort it through, right? Because I know it's one of the things like when it comes up for me, it's always helpful for me to talk this through. Have I thought it through? Am I right? What are the parameters? And even like pulling up like the statute. Let me read the statute again. Do I understand it correctly? Using standpoint.
Shuana?
Is it Shua?
Shuana.
Shona. Yeah, okay, so just to reiterate, so if we did mandated reporting on a student, you're saying we don't have to tell the school unless there has been a information released or consent, right?
Right. You can't release that information to the school as a mandatory reporter.
Okay.
Because what mandatory says, I release to law enforcement or the child welfare system. That's you're prohibited from releasing information unless one of these things happens to allow you to share. What's happened is it's a mandatory report, and that says you can share personally identifying information about the maltreatment with law enforcement or child protection. That's as far as you can go.
Mm-hmm.
Everything else has to happen through another gate, and that gate would be a release of information. Make sense?
Could you talk about a best practice for getting a release of information from a student? Because since it has to be voluntary, et cetera, we don't want to force them.
Right. So that's why I would say, so really it's sort of like, it may be really beneficial. I would say I can think of lots of scenarios where it's going to be really beneficial for you to be able to share information with the school when you make a mandatory report, right? So because child protection comes in, they're going to take action, right? But this may be a student where, having the school counselor or a teacher or somebody within that school system who's a support to this child, right? Or who's right, it'd be helpful if they had the same information. But you have to get a release of information, and it needs to be informed and voluntary. So I would sit down with a student, right? Because you already have to let them know you're making a child protection report. And then to sit down and talk with them about what information do you think would be helpful to share back with whom at the school, right? So what information, for what purposes, with what kind of impact? So it's a discussion, right? So they can be fully informed. And then if they're like in agreement, or they may say, you know what, I'm okay with you talking with this person, but not with that person, right? They get to control it. It's their information, right? So, and I'm going to get to the minor question in just a moment. But so that's sort of what I would call best practice. And the other thing is to be time limited, right? You need to have an end date on your release of information. So what's a reasonable time period that right? And that's going to be really circumstance dependent, right? So, and if you aren't sure, you know, I would always err on the side of shorter and then renewing it than going really long. So can we tell the school that we made a mandatory report? Well, here's the question. Let's go back to, if you tell the school that you made a mandatory report, are they going to be able to tell which person you reported on? If the answer is yes, so I could see you're at something, right, that something happened and they're probably going to suspect there might have been maltreatment. And then you say, well, we had to make a mandatory report. And if they go, okay, got it, I know who you're talking about, that's prohibited. Okay. You can't, right? Even if you didn't name them, if they can guess who you're talking about, you can't do that. If you say generally, you know, like we've made a report this month, right? They aren't going to know who. You could do that, right? Or right? So that depends if you tag the person themselves by how you do it. In terms of, can a student sign a release of information if they are a minor? It depends. The most common legal answer to anything is it depends. So most of the time that you are going to need a release of information, you're going to need a person, a parent, a guardian to sign releases of information on behalf of the minor. But there are certain circumstances where you may not need to. While Minnesota doesn't officially recognize emancipated youth, right? There are some limited circumstances like youth who have children and on public benefits living on their own are, right? Those kind of categories should be able to sign a release of information on their own, right? But if you have a child, a minor who's living at home with a parent or guardian. Now the other thing, and this is where I would go to standpoint, you may have a minor who is living at home with parents who are the perpetrators of the abuse that you want to report, right? Then there is, and that's why that depends. There are ways in which they can sign releases of information if to have to disclose to the parent further endangers them. But that's where I would seek, I would call up Standpoint and ask them because it's going to be dependent. I know it's not as helpful as a clear-cut answer. Other questions? Well, I know we're a little bit over time, but hopefully this was
Shona has another question.
Oh,
Okay, sorry, another one. I think I might know the answer, but I just want to ask out loud. What if there was an incident that happened at school? Then,
No, what if the student disclosed that information to you and you were working with them at the school? That still means that we do not tell the school that we reported it, right?
did you hear that, Liz?
Right. Yep. It doesn't matter where it happened. Now, somebody at the if something happened at the school, there, you know, most of the people in that school building are mandatory reporters as well, right? If they saw and observed it, they have to report independently. But here's the other little thing: just because another mandatory reporter reported it, and you reported it, you don't get to talk to each other. Right? That's why thinking it through, unless you've got that release. Yep.
Thank you.
So, and then I know Pamela has the PowerPoint as well as and this is recorded. So if you want it in a PowerPoint form, you can certainly take it.
Yeah, we'll send that out to everybody along with the link for the recording.